Okay, all right, we'll get started. So as I've said, thank you all so much for joining us for our fifth lecture of our series. It's hard to believe that we're at number 5. It feels like we've just started the series, and with just 3 left to go. I don't know what everybody's going to do in July on Wednesday evenings. I'm just kidding. So thank you all. There's been so much great interest in this series. It's been really great to receive lots of good feedback and to see that lots of people are interested. Hopefully it will generate lots of future animal law lawyers. And if nothing else, we'll have lots of people advocating for their interests. Before I introduce our speaker this evening, I just want to quickly go through a few housekeeping bits. I apologize, I probably sound like a broken record to those of you who have been attending all of the series, but just for those who are new to the series, to make sure that you're able to partake in the Q&A, you can see at the bottom of your screen a little Q&A icon. So if you do have a question throughout this evening, please pop your question into the Q&A. And if you want it to be anonymous, please just make sure you select Submit Anonymously so we can't see your name next to your question. And very lastly, we have a feature that you can vote up other people's questions. So if you see a question that you would like to have answered, please just vote the question up. So at the end, we can ensure we answer all the questions, and then of course the ones that have gained quite a lot of popularity. Okay, so as I've said, thank you all so much for joining us this evening. We have Mike Radford who will be presenting for us, and Mike is going to be speaking about the Animal Welfare Act. Mike is a reader in law in the University of Aberdeen, and over the course of 30 years, he has extensive experience of teaching animal welfare law and working with politicians, officials, NGOs, and professional bodies in developing public policy towards non-human animals. So let's all give Mike a warm, silent round of applause. Thank you, Mike.
Thank you very much, Tiffany. Greetings from deep in the Highlands, which is another way of saying I hope that the relatively weak wireless signal lasts for the next hour. Many thanks for joining us this evening. So these 3 pieces of legislation replaced the Protection of Animals Acts, and they were intended to provide an up-to-date legislative framework for domestic and kept wild animals, and to extend welfare provisions to all such animals, to provide enabling powers for secondary legislation to be passed, and to permit early intervention to prevent unnecessary suffering and poor welfare, and finally to improve enforcement. The 3 pieces of legislation are very similar to one another. The Scottish one, as you can see, it's part 2 of an Animal Health and Welfare Act. The second part of it is very similar to the English and Northern Irish legislation, but there are 1 or 2 differences which I'll highlight as we go. I don't want to be offensive, but I think between the 2 pieces of legislation, the Scotland is slightly better. So we've got the way that the welfare acts work is that, and this is a simple diagram, you have the WTO at the top, the World Trade Organization, and EU law, at least for the moment, dominating legislation relating to animals used for commercial purposes. And wildlife and scientific procedures also come under EU law, but then kept animals, and whether domesticated or captive wild animals, may come under EU law, but all of them also come under the Animal Welfare Acts. The scope of the Act, the animals that it applies to, there are two criteria. First of all, animals that are vertebrates other than man, and secondly, they have to be what are termed in the legislation as a protected animal. And to be a protected animal, it has to meet one of three criteria. Either commonly domesticated in the British Islands, or under the control of humans permanently, or not living in a wild state. In a vast majority of cases, it's going to be clear that an animal doesn't fall into the legislation by virtue of one of those first two bullet points. Not living in a wild state, it's not really clear what that means, and it's not been tested in the courts to date. We do know that it doesn't apply to birds coming to bird tables, because ministers made that clear when the legislation was before Parliament, and presumably it doesn't apply to other types of animals which may rely pretty heavily on humans giving them food, but are still essentially living wild and making their own choices. There's clearly a case where, if we take fish, a fish in an aquarium is clearly under the control of humans. A fish in a garden pond is under the control of humans. A fish in a quarry, which is what that picture is, may or may not be living in a wild state. Clearly there's a line between the first and second pictures there, but it will ultimately be up to the courts to decide where that line is. There are two exemptions. Anything done lawfully under the Scientific Procedures Acts falls outside animal welfare legislation, but anything which is done unlawfully using animals in scientific procedures can still be prosecuted under this legislation. And anything done in the normal course of fishing, that is both angling and commercial fishing, are exempt and fall outside the legislation. The next provision is really important, because one of the principles behind this legislation was that it should emphasize the responsibility, the nature of legal responsibility that humans take on in becoming, owning or looking after animals. And the way the legislation is framed is a lot of the provisions relate to, quote, a person responsible for an animal. And there is a section in the legislation which defines what that means. It's anybody who has either permanent or temporary responsibility for the animal, and that includes being in charge of it. And the legislation states that the owner is always responsible. And this is one of the advantages, there aren't many, but this is one of the advantages of animals still being regarded as property, in that if they are property, they will normally be owned by somebody, and that person can ultimately be held legally responsible for that animal's treatment. And I think it's something which should be much more emphasized. There should be notices in vets' waiting rooms, there should be notes wherever animals are sold, making it clear that you're not just taking on a moral responsibility, but you are taking a serious legal responsibility as well. Persons who are under 16 can still own animals, but the law states that so far as the welfare of those animals are concerned, that will be the responsibility whoever has legal responsibility. The provision defining responsibility, I think, is really important. You will be aware, or many of you will be aware, of the traditional offence of cruelty, which turns on unnecessary suffering, which was previously in the Protection of Animals Acts, which dates back to 1911 and 1912. Essentially, the offence of cruelty is restated in the 2006 Acts without any significant change, apart from the word cruelty is dropped, and it now focuses exclusively on unnecessary suffering. That doesn't make any material difference in terms of the offence or the law. I think it's unfortunate because people, even if they don't know what cruelty means in a legal way, it's a word which does have an impact. But anyway, it's disappeared from the legislation, which now focuses exclusively on unnecessary suffering. And as was previously the case, the legislation states that suffering can be mental or physical, but clearly mental suffering is more difficult to demonstrate to a court beyond reasonable doubt. And the idea behind the way that this offence is now set out is that it hasn't changed the law, but it has incorporated the pre-existing case law into the legislation. And I'll explain that as we go along. So far as the offences are concerned, in England, Wales and Northern Ireland, there are 2 offences, and in Scotland, there are 3. And in terms of the drafting, I think Scotland has got it right. So I'll deal with Scotland first. Offence number 1 can be committed by anybody, regardless of whether they've previously had anything to do with the animal at all. And so it says that any person may be guilty of an offence if they cause a protected animal unnecessary suffering by an act, and it has to be an act of commission. And they knew or ought reasonably to have known that the act would cause the suffering or be likely to do so. So this is the offence which is used generally if a person hasn't had anything to do with the animal previously, and the cruelty, the unnecessary suffering is caused and can only be caused by a positive act. The second offence is the one which is the basis of the vast majority of prosecutions. It is restricted to a person who is responsible for an animal, as previously defined, may be guilty of an offence if they cause a protected animal unnecessary suffering by an act or an omission, and they knew or ought reasonably to have known that the act would cause suffering or be likely to do so. Now, what is important about this offence is that the vast majority of prosecutions for unnecessary suffering are not the result of deliberate cruelty. They are the result of negligence, of people, for one reason or another, failing to treat or look after their animal properly. And so it is absolutely essential that the offence covers failures to act, hence the word omission. And secondly, the mens rea here, the mental element, is an objective test, as indeed it is with the first offence, that they knew or ought reasonably to have known, and the reasonably to have known is based on what the reasonable person would have thought in those circumstances. And these two things are really important because there are lots of offences of cruelty around the world, but not that many of them extend to failures to act, and not that many of them are reasonable person tests. It's generally, or many of them, the cruelty has to be by a positive act and has to be done intentionally. And if that's your test, then that cuts out an awful lot of situations which would be prosecuted in this country. And the third offence is the indirect one. That's where a person responsible for an animal, me, causes unnecessary suffering by an act. Another person causes unnecessary suffering by an act or omission. So Tiffany's looking after my dog, and she is the person who causes unnecessary suffering, but I, as the owner, have either permitted that to happen or I've failed to take such steps as are reasonable in all the circumstances to prevent it happening. So more than one person can be held responsible for the treatment of their animal at any given time. The English and Welsh legislation tries to do the same thing in 2 offences instead of 3. This is offence number 1, and my view is that there's actually a drafting error here, because which is I don't think it will be successful in court. But if you look at this provision literally, what it is doing is imposing a duty, regardless of whether you've had anything to do with the animal previously, to prevent it suffering unnecessarily, because it says any person, so it's not a person responsible for an animal, but any person may be guilty of an offence if they cause a protected animal unnecessary suffering by an act or a failure to act. And it's meant to do the same thing as the Scottish offences number 1 and number 2, but it seems to me that the Scottish separating the 2 out is a better way of doing it. And offence number 3 is the indirect offence, similar to that of Scotland. So in order to be found guilty of an offence of unnecessary suffering, the court has to be satisfied beyond reasonable doubt that the animal has suffered, and then the question is whether or not that suffering was unnecessary, and that question, the necessity one, falls to the court. And it used to be left entirely to them unless they were put on notice of the relevant case law, which didn't that often happen. What has happened? There were 3 cases, but 2 principles. One from 1889, Victorian case called Ford and Wiley, which is where the objective test of mens rea comes from, and 2 cases which were decided on consecutive days in the 1990s, RSPCA in Hall and RSPCA in Isaacs. And essentially what this provision does is to incorporate the tests which were laid down in those cases so that they are now in the legislation. So what the court is asked to do is in determining whether suffering is unnecessary, they ask themselves, could it reasonably have been avoided or reduced? That is from the cases of Hall and Isaacs. Is it otherwise lawful? Was it for a legitimate purpose? That is from the case of Ford and Wiley, and examples are given in the legislation that the suffering benefited the animal itself or protected a person, property, or another animal. Was the suffering proportionate to the purpose, and it really should have legitimate purpose there? That comes from Hall and Isaacs. And was the, proportion that comes from Ford and Wiley, and was the conduct in the circumstances that of a reasonably competent and humane person? That comes from Hall and Isaacs. So if you look at this provision without knowing the background, it seems very odd, the test, the wording, but as I say, what they were trying to do, and what they have done, is to incorporate the existing case law into legislation. There are a number of miscellaneous provisions in the Act, some of which were new and some of which were restatements of provisions in the Protection of Animals Act. Docking of cosmetic docking of dogs' tails is unlawful, but docking of dogs' tails can still be lawful in some working breeds. Cruel operations, that essentially means that, and was a pre-existing offence, essentially means that an animal has to have anaesthetic, be anaesthetised in operations. And operations in that context can be small things, simply there's one case, for example, where a dog groomer cut with her scissors a piece of loose skin on a dog she was grooming and attempted to sew it up without giving it any anaesthetic. Just sewing that up constituted an operation for these purposes. Administration of poisons is a carryover from the previous legislation. So is fighting and baiting, but the provisions were enhanced in the new legislation. Just as an aside, fighting and baiting of animals was the first activity to be banned outright in UK animal protection legislation. It was banned in England and Wales in 1835 and Scotland in 1850. All three acts have a provision, and this is a new provision, in relation to offering animals as prizes. Only Scotland gets it right. The idea behind this is that taking on responsibility for an animal should be a reasoned, positive decision rather than a matter of chance. And in Scotland, it is an offence to offer animals as prizes, full stop. In England and Wales, it's an offence to offer an animal as a prize to anybody under 16, which completely misses the point, because the principle is about chance and the person's age is totally irrelevant. There is an exception in both jurisdictions. You could still offer an animal as a prize within the family. So people can still be offered ponies daughters could still be offered ponies if they passed their exams. The two other provisions there are put in brackets. They only apply in Scotland. There is a provision which allows government ministers to, by regulation, to prohibit the keeping of certain animals. It hasn't been used to date, but could be used. I think it could be particularly useful in these cases where there's a new film or a new television program and some exotic animal suddenly becomes fashionable. This allows for the government to step in at a very early stage and prohibit the keeping of such animals. And there was previously in England, Wales and Scotland an offence of abandonment. It was done away with, abandoned, in 2006 in England and Wales, but Scotland have kept it as a separate offence. Now, it's important to make a distinction between cruelty and welfare. Clearly, there's an overlap. Clearly, both are essential, and I'm not for one moment decrying the offence of cruelty. When we're talking to jurisdictions, to countries that don't have any animal protection legislation, cruelty is where we start. So it is essential, but it has shortcomings. It's negative. It tells you what you must not do. You must not cause an animal unnecessary suffering. It doesn't impose any specific positive duties. It focuses entirely on suffering, and an animal's condition can be unsatisfactory and unacceptable without it necessarily suffering. The offence is entirely retrospective. It doesn't actually protect animals from cruelty. What it does is make the responsible person accountable after the offence has been committed. And beyond reasonable doubt is a high threshold. So we still need an offence of cruelty, but we need another line of legislation. We need legislation which imposes positive responsibilities on those who take on animals, that focuses not just on suffering, but on quality of life, which is prospective and allows for early intervention to either avoid the problem arising or getting the animal out of that situation. Most welfare problems are relatively easy to address. You either change the situation in which the animal is being kept, move the situation, you move the animal out of that situation. And it's this second group of legislation which represents welfare. There were previously welfare provisions coming mainly from the European law and relating to commercial animals, particularly farm livestock, scientific procedures, and zoos. But what the 2006 legislation does is to impose welfare requirements in respect of all kept, domesticated, and captive wild animals. And although it's called the welfare offence, and the title at the beginning of the section, relevant section, says duty of persons responsible for animals to ensure welfare, welfare isn't actually, the word welfare isn't actually used in the offence. What it says is a person commits an offence if he or she does not take such steps as are reasonable in all the circumstances to ensure that the needs of an animal for which he is responsible are met to the extent required by good practice. Three things to say about that is this is about, to emphasise that it's about needs, the needs of the animal. Secondly, the word reasonable appears there, and that might make you think, and does make some people think, that this is therefore an objective mens rea test, the reasonable person test. I don't think it is. I think the reasonableness turns on the circumstances. It's part of the actus reus, and I would argue that this is a strict liability offence. The sting in the tail is the provision to the extent required by good practice. And in respect of some types of animals, the governments have issued codes of practice which are intended to lay down provision, essentially demonstrate what good practice is expected to be. But clearly this leaves quite a lot of discretion open to the court. The legislation specifies some needs, but this is not comprehensive. The court can take other considerations into account if it considers that to be appropriate. But the listed things are the need for a suitable environment, the need for a suitable diet, the need to exhibit normal behaviour patterns, the need to be housed with, or as the case may be, apart from other animals, and the need to be protected from pain, suffering, injury and disease. They echo the 5 freedoms with which many of you will be familiar. The wording has been changed because it was felt that freedom from something sounds negative, whereas this is about positive duties to provide positive needs. Enabling powers, one of the huge disadvantages of the old Protection of Animals Act from 1911 and 1912 was that it had no enabling powers at all. In other words, there was no provision to introduce secondary legislation. And that meant that if you wanted to change or enhance the law in any way, it had to be by another act of Parliament, which meant that relatively few things got done. And by and large, when they were done, it was on the back of private members' bills. And it was one of the reasons that prior to 2006, the legislative regime was very messy and had really no coherence. Not as many regulations as one would have liked have been passed in the last 14 years, but a number have. 2 provisions, either regulations to promote welfare or regulations introducing licensing or registration schemes for activities involving animals. They're common to all 3 welfare acts. And as I already mentioned, there's an additional one in the Scottish legislation prohibiting or providing for regulations to prohibit the keeping of certain types of animals. And these were going to be backed up by an extensive array of codes of practice. Those have rather hit the buffer, well, they hit the buffers some time ago. There are codes of practice. There's one on dogs, there's one on cats, and one on rabbits, a number of other ones. But the whole issue of what is good practice in looking after an animal, there's clearly room for debate about that when it comes to courts. Policing the Act, and this is where the single greatest weakness appears. The 2 groups of people who have powers under the legislation are police constables, who, with all due respect, generally have no knowledge of this legislation and little interest in it. And so the focus is on inspectors. These are inspectors appointed under the Act, either by their nationally by the relevant government. So for England, it's DEFRA. For Scotland, it's the Scottish Government, Welsh Government, Northern Irish Assembly, or by a local authority. Now, the weakness in the legislation is the appointment of these inspectors is entirely discretionary. And this is a good example of where you get almost a really good law, and then it is undermined by politics. The reason that the appointment of these inspectors is discretionary is because, and I can still hear it ringing in my ears from government ministers, the intention was that the Animal Welfare Acts would be financially neutral. And what they said was, if we impose a duty on local authorities to appoint inspectors, they will want money to carry that out, and no money has been provided, no extra money has been provided under this legislation. So it is entirely discretionary. And that means that right from the beginning, there are a number of local authorities that have never appointed inspectors under the legislation, and those that have in the past, you will readily appreciate the demands and restrictions there are on local authority finances even before the present situation. And there are a lot of local authorities that have either stopped appointing inspectors or have cut back very much on this. So there is a real issue of enforcement here. The RSPCA and the SSPCA are in different positions. No RSPCA inspector, as far as I'm aware, has been appointed as an inspector under the Act, and the government's position for that is because the RSPCA both investigate and prosecute. It would be wrong for their inspectors to have powers under the legislation. In Scotland, the situation is different because here we don't have the same tradition of private prosecutions. Practically everything is done through the public prosecutor, Crown Office and the Procurator Fiscal Service. And because the SSPCA does not itself bring prosecutions, a number of their inspectors have been appointed as inspectors under the Act. Really important provision, because as I said at the beginning, the idea behind the welfare offence was, first of all, to impose positive duties so that the needs of the animal were met, and secondly, to provide provision to prevent poor situations escalating, essentially to prevent the need to prosecute people for unnecessary suffering, because problems would be addressed. And important difference here, and it's in more than just the name. In Scotland, these are called care notices. In England and Wales, they're called improvement notices. And what they do is they allow an inspector to identify a welfare problem or even a potential welfare problem, to state what must be done to address it, and to define a time limit within which it must be addressed. In Scotland, it is an offence in its own right to fail to comply with a care notice. In England and Wales, it is not in itself an offence. A failure to comply with a care an improvement notice can be used in evidence for either an unnecessary suffering or a welfare prosecution, but it is not an offence in its own right. And of course, RSPCA inspectors are not formally permitted or authorised to issue improvement notices because they're not inspectors under the Act, but they have their own version of such a notice which they do give to people, and it is just as effective. It's the biggest single difference that this legislation has made has been through care improvement notices, I think, and they do the job. They do the job very efficiently. So, for example, if I'm an inspector and I'm passing a block of flats and I see that a dog is being left out every day on a balcony 8 floors up, no shade, no water, it's on a lead which is tied to the rails and it could fall through the rails. and strangle itself. I don't have to wait until the problem actually begins to impinge on the animal. I can identify the problem, which is that this dog is being left out on a balcony with in an inappropriate situation. I can state what should be done about it. It should be given shade, it should be given water, the space between the railings on the balcony should be blocked in, and I can lay down a time limit within which that must be done. And that is a really good provision. And talk to the RSPCA and the SSPCA, they have nothing but praise for the impact of this. And it can also play into the power to take animals into possession. I can see we started late, or carry on, if that's okay, or do you want me to stop?
Sorry,
Is
Mike.
it okay to carry on?
Yeah.
Because we started late, I'll go past the hour. Is that all right?
Yeah, that's fine. Yeah.
So the power in relation to animals in distress provides that the veterinary surgeon certifies that a protected animal is suffering or likely to suffer if its circumstances do not change. The inspector or constable may take that animal into possession. Clearly, if a person has been already issued with a care or an improvement notice and the situation hasn't improved, that can be used as evidence that the animal is likely to suffer and its circumstances are unlikely to change. Sentencing is a term of imprisonment or a fine or both. By and large, that isn't the sanction which prosecutors are going for. They're going for the third one, disqualification orders. Deprivation order is where the owner of the animal has been convicted of an offence and they haven't previously agreed to sign over ownership. The court can deprive them of ownership and give ownership to somebody else. Disqualification orders are where anybody, regardless of whether they're the owner or not, but anybody found guilty of a fighting, baiting offence, an unnecessary suffering offence, or a welfare offence can be disqualified. And in England and Wales, the disqualification can be for any of these, either owning animals, keeping animals, participating in the keeping of animals, being party to an arrangement under which a person is entitled to control or influence the way in which animals are kept, dealing in animals, or transporting or arranging for the transport of animals. The list in Scotland is slightly longer and more comprehensive. Animals or dealing in animals, transporting of animals, working with or using animals, riding or driving animals, providing any service relating to animals which involves taking possession of animals, taking possession of animals for the purpose of a disqualified purpose, and just in case we've forgotten anything, taking charge of animals for any other purpose. Now, these disqualification orders look good on paper. There are a number of problems. One is that they are entirely up to the court whether or not they make a disqualification order. And I think one of the things which tends to happen is they regard these disqualification orders as part of the penalty. And having given a fine or term of imprisonment, they think that's enough. These should not be regarded as part of the penalty. They're part of the sentence, but they are not part of the punishment. What they should be regarded as a measure to protect animals going forward in the future. They should be totally separated from any fine or term of imprisonment. The second problem is that there is no central database. There's no really open record of who's got these orders made against them. And the third thing is that, again, on paper, it looks good because the court has the discretion to make these disqualification orders in relation to all animals or particular classes of animals, sheep, dogs, whatever. And the court has the discretion to make these orders for whatever duration it thinks fit, including for life. However, anybody who's had a disqualification order made against them can go back to court after 12 months and ask for it to be varied or terminated. And if they are unsuccessful, they can go back every subsequent 12 months asking for it to be varied and terminated. So a lifetime ban may not be all that it sounds as though it's going to be when it's reported in the press. Issues around the Animal Welfare Acts have made a positive difference. Issues around them, just awareness. As I said previously, I think there should be much more publicity, not necessarily about the detail of the legislation, although the welfare offence should receive more publicity, or the nature of the positive responsibilities, but the sheer emphasis that you are taking on legal duties when you take on responsibility for an animal should be much more publicised. The importance of enabling powers is good, but the law has not made as much progress in the last 14 years as one would have hoped using these. Enforcement is a huge issue for reasons that I've described. And if there were two other provisions that I would like to see in the legislation, one would be a specific duty on anyone breeding an animal to have regard to the welfare of the female and the offspring prior to the mating. That provision already applies to pet animals, to companion animals, under the European Convention for the Protection of Pet Animals, but of course the United Kingdom has not signed up to that convention. And secondly, I think that there ought to be a duty on anybody disposing of an animal, which is an unfortunate word, but what I mean by that is anybody giving, selling, or otherwise passing ownership of an animal to take reasonable steps to satisfy themselves that those to whom they're passing that animal are equipped to meet its welfare needs. I just put this picture up. I put it on end of quite a lot of my presentations. It's a picture by Banksy. It used to be called the Chimpanzees Parliament, but he changed the title last year to the Brexit Parliament. But as you can see, it's a depiction of the inside of the House of Commons, occupied not by humans, but by chimpanzees. And I will leave you with the question, how do you think the law would be different if it were they who were deciding on its provisions rather than Homo sapiens? Happy to take questions. I'm conscious that a lot of you, or all of you, would have thought that we would be over by 8. I've put my email address on there. If there's anybody who has to go but would like to pose a question, they're welcome to email me. Thanks, Tiffany.
Thank you, Mike, very, very much for your presentation. And yes, thank you everybody for your patience. I guess technology is a blessing when it works well. and when it doesn't, not so much. Thank you so much, Mike, for the presentation.
As I say, I apologise for the problems at the beginning, but hopefully we made up for them as we went along.
Yes, I think so. It was much better afterwards. So thank you again so much. And I'm sorry you had those issues. And thank you everyone. Thank you everyone for your patience and sticking with us through the lecture this evening. Mike, thank you very much for taking your time to be with us. And we're very much looking forward to next week as well. So next week will be our 6th lecture. And we're going to hear from Dr. Steve McCulloch. Steve, I hope I've pronounced that correctly if you're here. And Steve will be talking about representing animal issues in public policy. So again, thank you so much, Mike, for being with us, and to everybody else. And we'll see you again next week, Wednesday at 7 p.m. Thank you so much.